Throughout U.S. history, courts have upheld public health laws and regulations in large part on the basis of their importance for protecting the well-being of communities. But recently, the Supreme Court has imposed new legal principles that impede the ability of states, Congress, and agencies to use public health evidence to protect the public. I'm Stephen Morrissey, managing editor of the New England Journal of Medicine, and I'm talking with Joshua Sharfstein, distinguished professor of the practice in health policy and management at the Johns Hopkins Bloomberg School of Public Health. Dr. Sharfstein has co-authored a perspective article about the Supreme Court's evolving approach to public health. Dr. Sharfstein, could you describe how the Supreme Court has typically responded to efforts by states and federal agencies to protect public health? What kinds of actions has it allowed in the past, and what has it not allowed?
So, one of the reasons that the U.S. was founded was to promote the general welfare. That is part of the Constitution of the country. And James Madison wrote in the Federalist Papers that the public good, the real welfare of the great body of the people, is the supreme object to be pursued in government. And since the origin of the Republic, there have been many, many types of actions that have been taken to advance the health of a population, which is public health. And courts have respected those by and large because that is one of the reasons we have a government, to make a difference in people's lives and to make sure that people are protected from pandemics, from infectious disease, from other types of hazards. And so what that generally looks like is that states have a pretty wide berth to take actions. It's called the state police powers, and those are respected unless they violate fundamental federal constitutional obligations. And the federal government is understood to be in the business within its lanes of supporting the health of people in the United States. And that has taken many different forms. You know, in the paper, we talk about how it kind of all started with a yellow fever outbreak and Congress telling President George Washington to do what it took to support efforts to put down the outbreak. It's been really part of American government to support reasonable public health actions since the beginning.
But in your perspective article, you say that in recent years, the court has taken a different approach. So when did that shift begin, and what reasoning has the court used to block actions related to public health?
Well, it's really a set of doctrines that have come out of the Supreme Court recently. And they have kind of maybe emerged particularly over the last 5 to 10 years, but particularly in the last couple years. And we're starting to see them all hitting at the same time. And oftentimes you'll read an article about one doctrine or one thing that's going on with the Supreme Court or another one. But what we tried to do in this piece is talk about how they're all kind of happening at the same time and they're pointing in the same direction. So, for example, increasingly, the court is questioning whether states can do things to protect the public. And they've been second-guessing states. That happened during the pandemic, for example, when California tried to treat churches and synagogues like movie theaters and concert venues for the purpose of controlling COVID. And the court struck it down and didn't really pay attention to the scientific argument that the state was making, leading Justice Kagan to write in dissent that the court was forcing California to ignore its expert scientific findings and impairing the state's effort to address a public health emergency. Another example of that is we're seeing in gun laws, where states are using evidence to put in place reasonable gun restrictions. And the court is now striking those down if they are not analogous to laws that were enacted well over 100 years ago, when guns look nothing like the guns they look like today. And that has created a whole new set of challenges to states being able to use public health evidence to protect their population. So that's one kind of category of what's happening with the court. But we're also seeing a lot more skepticism about the actions of federal agencies too. And in 2022, the court announced what it called a major questions doctrine, which says that agencies are only allowed to do the things that Congress specifically told them they could do. And Congress is not allowed anymore to give broad direction to agencies like protect the safety of food and drugs. It's got to be much more about here's how you should do that. Well, the problem is these laws were written generally because that was what made sense to Congress, that they wanted to leave some of these decisions to experts at the agencies. The court is now second guessing that and striking down different kinds of regulations, including the ability of the Occupational Safety and Health Administration to put in place a policy on COVID, and including the ability of the Environmental Protection Agency to put in place some policies on climate change. It is a really restrictive, potentially restrictive doctrine because, of course, Congress can't anticipate everything that's going to happen, and Congress doesn't have the expertise to be regulating at this level of detail. And then there's more, because there are new cases coming out that have to do with whether the courts will defer to agencies' interpretations of the laws that they enforce. That could have a very challenging effect on the ability of agencies to move forward. And you then, of course, even have these cases like the mifepristone case, where the court is considering a fundamental challenge to the FDA's ability to regulate medications, where the FDA is trying to improve the health of the country, and the court is considering whether there's like a moral injury to certain doctors who might have to take care of the consequences of a mifepristone adverse event, whether that overrides the ability of the FDA to set policy for the health of the country. So it's a lot of little strands, or maybe they're not so little strands, but what it adds up to is something very different than what we've had in U.S. history.
So let's look at those cases that are going to be decided this term more closely, starting perhaps with Relentless versus the U.S. Department of Commerce and the Lober Bright Enterprises versus Raimundo. Which issues are being considered in those cases, and what could be the implications of the court's decision?
Well, those cases are about what's called the Chevron doctrine, and that refers to a case that was called the Chevron case, where the Supreme Court said that a court should defer to agencies in resolving ambiguities in the laws they enforce. So what this looks like is, say that a law talks about a certain type of food, but it's not totally clear what counts. Well, then the agency gets to decide that. And as long as that's a reasonable interpretation, the court should respect that. These cases are likely, according to some people watching the court, going to lead to the overturning of that doctrine, which means there shouldn't be deference to the agencies, that the court can come in, and it could be any court, any judge, show up and say, actually, we get to decide what counts as that kind of food. And oftentimes, when there's that initial determination by the agency, there's a logic. It's people whose job it is to support the public health, who are putting in place a policy that makes sense. But then if the court comes in and doesn't give any deference to that and just starts on its own, it could be any agenda that the judge has could lead to a change in policy, and the agency's work could be struck down, I think, inappropriately. So that is the risk, that what we're talking about with these cases is a shift from the ability of scientists at agencies to make reasonable decisions to judges who could show up for whatever reason and say, I don't like the way you did that, I just want to change it.
And then what about United States versus Rahimi? Why is that case important?
So in this case, the court is confronting the consequences of some of its previous decisions, particularly that decision I mentioned about requiring gun laws to be analogous to laws from the 18th or 19th century, because it pertains to a federal law that exists now that prohibits people who are subject to domestic violence-related restraining orders from obtaining guns. And this is a law that has a lot of evidence, because people who perpetrate intimate partner violence are much more dangerous. And when you take guns away from them, there are fewer homicides. The court has to decide whether it's going to strike down this law that makes sense simply because there wasn't an analogous law in the 18th or 19th century. And if it does that, more people are going to die as a result. Now, it may be possible, though, for the court to have a pretty loose interpretation of its previous standard and say, well, it's analogous in a very broad sense to some other laws that existed, or maybe they could even change that doctrine altogether. So we're going to see how strictly the court is going to adhere to that prior decision, whether it's going to mitigate or moderate its position, or whether it's going to double down with pretty significant consequences for health.
And then the fourth case, which you've already talked about, is FDA versus Alliance for Hippocratic Medicine. How will that decision affect both reproductive health and agency authority?
I think a lot of the attention is appropriately on just the facts of the case and what a decision could mean, because mifepristone is so important to reproductive health access in this country. This is a case where a judge basically said that mifepristone should be taken off the market. And then an appeals court kind of modified that, but still significantly changed what the FDA said for this medication. And this is about this medication. It's about reproductive health, but it's also about the FDA. Because if the FDA can't be the agency that uses science to figure out how best to regulate medications, then we're basically up to the whims of judges who have no expertise in this area. And that is frightening, not just for reproductive health, but for many other conditions. And that's why there's such strong involvement here of the pharmaceutical industry warning about an adverse decision here that doesn't support the FDA. So again, I think this is an example of a case where hopefully the court will back away a little bit from the trend of undermining agency authority, that it will support the role of the agency, that actually it will put health as measured by health outcomes of people, which is what FDA considers, above a purported moral injury to a few doctors who are suing on the grounds that they don't want to take care of an adverse effect. And it's, I think, very important for the court in this area to support not only reproductive health access, but also the expertise and the approach we have in this country to using evidence to make our population healthier.
Finally, how could states, Congress, agencies respond to these increasing limits on their authority to protect the public health? What are their options if the court continues moving in this direction?
It's a great question, and it's not an easy answer. I think that the court, and it's not just the Supreme Court, but it's also lower courts, can start striking down a lot of policies if the Supreme Court keeps going in this direction. So it could be very difficult. You could see a lot of challenges. Anytime someone doesn't like a regulation, they could say, well, it didn't seem like it was specifically put forward by Congress, so could the agency legally have done this at all? Or you should rethink this agency interpretation. Chevron is no longer in effect. And that could really lead to a lot of wheel spinning at agencies in two regards. One is things could be getting struck down and the agency would have to try again. But also I'm worried that agencies are going to be overthinking it before they move forward with something and spending an extra amount of time before to kind of line up every single duck. And during that period of duck lining up, there can be harms to people. Regulation needs to be thorough and thoughtful, but it can't take forever in order for it to work. So that's a challenge. So I think agencies are going to have to try to find a sweet spot where they can do work that allows regulations to be upheld and at the same time have that work be impactful. How much room they have to do that, though, is really up to the court. And I'm hopeful that in this term, perhaps in the mifepristone case and that Rahimi case you mentioned on guns, we're going to see a little more room for agencies. I don't think this book has been sealed, but I think over time we're seeing that space get smaller. And that is something that should concern all of us, every physician, every person who is worried about health. Because if we turn our back on the commitment that this country has made to the general welfare, to getting people healthier and happier, it has consequences for us all.
Thank you, Dr. Sharfstein.